The way the webinar is going to work is that Adrian is going to sort of kick off by discussing Barder events, giving us an overview of that and how COVID-19 might impact on orders made shortly before the pandemic and lockdown began. If you have any questions about that, please feel free to send them through to everyone using the chat function. They're going to be moderated by Rakea. And then once Adrian's finished, we'll look at some questions. We will then move on to the contact section. And if there are any questions during that, then please feel free to send those through then. If there are any questions about Barder that come through later on, we can look at those as well. We just thought it would be helpful to split the seminar up into two distinct sections. Just to let you all know that the webinar is being recorded. So if you do have an issue with your face being recorded, then please do just take off the video function at the bottom. And can we please just ask that all of you mute at your end so that we don't get any extra noise coming through? We'd be really grateful for that. As you are aware, these webinars are being hosted for free, but we are using them as a means to raise funds for the National Emergencies Trust Coronavirus Appeal. That is the trust that is working collaboratively with a range of organisations to ensure the maximum amount of money raised is distributed securely, effectively and fairly to those organisations and local charities. Thank you all of those who have contributed. We have so far raised £120 and we will continue to be raising that money during this time. Our next webinar is going to be this Thursday, the 9th of April, which will be a public law webinar titled Law in the Time of Corona. Victoria Roberts and Caitlin Ferris will be joined by Children's Guardian Matthew Geary for a discussion on how to keep public law cases running with fair hearings during COVID-19. So if anyone is interested in that, please do sign up. There will be a link sent out afterwards as well. So to kick us off on Barder events, I'm going to hand over to Adrian.
Hi, everybody. So a lot of you are going to have heard of the term Barder event being thrown around in the COVID-19 crisis. And what I want to do is very quickly go through what is a Barder event from a legal perspective, whether or not a court is going to establish COVID-19 is a Barder event within that meaning, and then finally ways for us to insulate or arrange orders in these current circumstances. Just a small spoiler at the end, it seems unlikely that the courts are going to determine that the COVID-19 environment as it is really counts as a Barder event. So just quickly going through the principles, a Barder event is something that happens shortly after an order is either agreed, made, which undermines the entire purpose of the order. And what that is, whether it's an act of God, whether it's an act of an individual, that hasn't been dealt with hugely in case law. So we don't have a specific list of circumstances which automatically qualify as a Barder event. But what we do have from the eponymous case is the core principles. And the first point in this list of 4 from the Barder and Barder case is that the new event or events invalidate the basis or fundamental assumption on which the order was made. So it's not, I think we have to look at the wording of that very carefully. It's not as simple as it's a little bit harder for this order to work. It's not a case of it's going to be a little bit later. It has to fundamentally invalidate what the order was supposed to do. Now, briefly, in terms of the factual nexus of Barder and Barder, this was a situation where wife, in fact, killed the 2 children of the family and herself 5 weeks after the making final order. And then the assets transferred to wife's mother, that is the maternal grandmother. And as a result, husband came to enforce the order. That is a fairly straightforward example of how the order as originally made could not work, if only because there were no more children and there was no more other party. But if you look at the history that followed, and I'm going to refer to 2 other cases, I think one that's been thrown around quite a lot in discussions is Myerson and Myerson from 2019, where essentially the argued Barder event was the financial crash and the following recession. And actually the court didn't determine that that would count as a Barder event. Now, this forms relevant to what we're talking about when we talk about something like COVID-19, a sort of large social impacting event, as opposed to contrast in Barder and Barder, where there's a minute focused event within the circumstances of the parties. Now, Meyerson's unique in the sense that it refers to a consent order that was agreed between the parties. And essentially, the asset base, part of the asset base, husband was arguing, was massively reduced in value as a product of the financial crash. And what he was saying is that significant change in value dramatically impacted and therefore, as we put it from the Barder and Barder jurisprudence, invalidated the basis or fundamental assumption on which the order was made. Now, this is important in Meyerson because the distinction is that it was a consent order, and husband, working in the financial market, so the court said, agreed to the consent order, was aware of what the shape of the future could be, and as a result, not necessarily should have foresawn, but it was within the range of possibility that that crash was going to happen. The other element, and this is a procedural element, that the court didn't grant the appeal in this case, is because there was an alternative remedy in the form of a variation available to the husband, as opposed to what he was seeking was a strikeout of the actual order. The point is that, looking at those two cases for the moment and pausing there, the distinction on Barder events not only is within the jurisprudence about the fundamental change and invalidating the basis of the order, but it's also balanced, as it was in Barder, against a policy ground of, well, we don't want to delay proceedings, we do want finality, but we're not going to be particularly keen to change or reconsider an order on the basis of dramatic events unless it was truly, truly dramatic. And I think we can contrast the fact pattern of Barder as against Meyerson, not just on the fact that Meyerson was a consent order, but also because on observation, the dramatic impact on the order itself is more obvious. The change in valuation on the asset base in Meyerson isn't as dramatic as an entire party and the children of the family no longer being part of the actual order that was being made anymore. There is one case that I've noticed has been interestingly absent from a lot of discussions about this, and this is Critchell and Critchell, which is recently as 2015. And the long and short of this case is that after the order was made, husband's father died, giving him an inheritance of £180,000. And one of the significant liabilities in the asset base was a debt to the husband's father. With the death of husband's father, that liability no longer existed. And the wife actually brought the appeal on the basis that the death of the father constituted as a Barder event, which undermined the basis of the order, because that calculation of the £180,000 and the absence of the existing liability were now no longer on the table, so to speak, when they had formed part of the original order being made. Now, many of you might have come across this in terms of looking at realizable future inheritance assets within existing financial remedies proceedings. So what I find interesting is that the court actually did grant this appeal on the basis that it did, in fact, the inheritance of £180,000 from the husband's father did actually constitute a Barder event. This is really very much against the run of cases, and I haven't seen or found any cases in line with that follow. But it's worth bearing in mind that whilst we can sit here and observably say in the round, well, an incident, an event like the COVID-19 crisis might not or was unlikely to be considered a Barder event. We do have a case in Critchell and Critchell where something we come across very commonly in financial remedies cases in terms of the question of inheritance actually has the scope to be considered a Barder event. So I would really encourage people to consider the Critchell case because it goes against a lot of the existing jurisprudence that led up to it from Barder, although there hadn't been any cases decided on that basis since. So that's a brief cherry pick through the principles we're looking at. The second element of what I want to deal with is, and I think the answer to this is perhaps more straightforward, is whether this COVID-19 crisis constitutes a Barder event. Now, I stressed it at the beginning that something that simply delays the enactment and the application of an order itself is ordinarily going to be called a Barder event. Now, delays is a how long is a piece of string point, but how long is a delay? What's causing the delay? Is the delay a persistent concern or is it a short-term concern? We often have clients who sit in situations whereby, well, as it was as much as 6 months ago, well, Brexit makes the housing market uncertain. I don't know how much I'm selling it for. There are constant concerns about delays. We're facing, even before the COVID-19 crisis, when are we coming back for an FDR? When are we coming back for a final hearing? Barder events do not, from my assessment, they don't cover barriers that simply delay proceedings, that put things farther back. And from a, I'd say, holistic analysis, this current crisis constitutes as a delay. The problem is we don't know when that delay ends. Are we coming back within 4 months, 5 months, end of the year, 2021? We don't know. But it's going to be, the majority, and my view is it is the majority of circumstances with parties that may wish to argue that COVID-19 works as a Barder event, is simply because it constitutes as a delay, and that's not going to the fundamental basis of any order. Might not be the case, and it depends from, obviously, case to case. But the majority of these situations are going to be, well, I don't know when I'm able to sell the house because of the social isolation guidance and situations that cause some services not to be available. That's something to bear in mind if you have clients who are asking about this, because you need to assess the difference between, has COVID-19 actually completely frustrated the application of the order, or is it simply putting things back, which in reality it's putting everything back at this point. So what can we do? What is the best we can do about it? I mean, with many things when we're facing delays, whether that's court time and many other proceedings, or simply not knowing the future, which we're not asked to predict the future in any event. I would advise people who are either in the process of negotiations and looking at consent orders is either to ensure that if you have particular elements of an order like property adjustment or orders for sale, that you have, if you can, some level of contingency or some aspect of just in case, what is the alternative? The obvious answer is to accept that there will be delays to proceedings if the current status quo is sustainable. And I don't want to say short term, because short term can mean different things to a lot of people, but assuming we're going like this to the end of the year, for example, the best thing is to accept that we may be having hearings put off. I think the court system is hugely struggling, and there will come a point where if the restrictions are lifted, we're going to have an influx of cases at an enormous rate, which could create further delays. But generally, I would have to say the likelihood of a court finding COVID-19 as a Barder event really is quite remote. So in the majority of cases, we would have to be expecting that delay and preparing for hearings farther down the line would be an inevitability. The last option, if you have concerns, say, comparable to the Meyerson case, where you're concerned the COVID-19 environment could, for example, devalue assets significantly, is to keep an eye on updating valuations, much as you would with many other types of assets in long-running proceedings. What I want to stress is that whilst COVID-19 for many of us in a social sense, socioeconomic and professional sense, is making a huge impact on our day-to-day existence, evidenced by the very fact we are all here now, it is worth bearing in mind that there are already mechanisms within our own procedural guidance that help us move forward. If we need to seek later valuations because of the delays, those valuations can be directed, ordered, agreed. We need to be staying on top of the situation as far as we can, but bearing in mind that it's unlikely that COVID-19 can successfully be argued as a Barder event unless you have a very specific set of circumstances and a specific case. So that's me going through the broad headings and some useful points and tips to think about in the current situation. But I'm more than happy. We've got the chat open if people have any points of discussion, not just questions. Rachel, I don't know if you wanted to add anything else or any other observations from your own perspective.
I think let's see if there are any questions. I don't know if Rakaya is able to tell us whether any questions have come through.
I've not received any questions yet, but I've just prompted people to use the chat function to definitely send in any questions or comments you may have.
If no one has any questions right now, then we can move on. I don't know, to the contact session, and then if people want to sort of send in questions later, then they can. Okay, well, I think if nothing's come through, then we will do that, and then oh, hang on.
Oh, we've got a couple.
You've just got your first two questions here.
Okay, great. So we've got a question from Venetia. Would you delay negotiating a settlement now? And from G Chase, what about single joint expert valuations? Does anyone have any experience of surveyors still valuing properties?
I'll take those each in turn. Venetia, thanks for your question. Would you delay negotiating a settlement now? I'm not going to set a definite yes, no, because there isn't a definite yes, no. If you're waiting for further information that would have ordinarily been available, for example, and I'll deal with G Chase's question that follows about valuations, then obviously you need to make a judgment of how feasible it is to negotiate depending on the issues in front of you. Two of my potential FDRs, which were adjourned anyway this week, both settled, interestingly enough, because of the impending pressure of COVID-19. And I don't know what the issues were in that case, but it strikes me that there must have been some scope to settle, and it may have been last minute. I don't know what the issues were. I wouldn't say you can set a definite, we are not going to have any discussions about settlement, because there is a certain leverage you can obtain on parties during a time where they don't know whether they're going to come to court hearings. But if the issues are such that there are valuations missing, there are documents missing, that you couldn't agree a settlement in an ordinary state of affairs, then you may have to delay negotiating a settlement. I think it really depends on case to case and how far apart you reason you are. And just to G Chase's question, similarly, SJE valuations, certainly I have been told that my cases, we've got none available or they're being delayed. So we haven't successfully managed to obtain any in any of my cases. I don't know what your situation is, Rachel, then it's come up with yours.
No, I mean, I have, George Matheson, for example, has said that he will still take on doing pension reports, but there is a sort of 26-week time lag to get those back. So, I mean, I guess the hope is that by the time those are filed, that we'll, be in some degree out of this situation. So I don't know if that's having an impact on those particular reports.
Well, I hope that helps everyone. Obviously, we still have the chat. Catherine Campbell's just asked a similar question to G Chase's about SJEs, about businesses. Or any idea how the courts might approach them?
I suppose it really depends on what kind of business it is. That's going to have a huge, I mean, obviously it's a business in the retail sector, for example, they're going to have taken, it's going to be a different story to other businesses, which, for example, technology businesses, which will have gone the opposite way. I mean, I think it will really vary sector to sector how COVID-19 impacts on the value of any business at this time, and whether or not it's going to have a long-term impact or whether it's a short-term impact. I don't know what you think, Adrian.
In terms of businesses, one thing I would say, Catherine, it's Rachel's right in terms of the value of businesses is presumed, depending on what they are, hugely variable at this time. You would inevitably, when we all start coming back, if we all start coming back to court, you'll need to seek further valuation, up-to-date valuations in any event, because as Rachel said, if it's a retail business or something that depends on the availability of actual social contact or premises, you're struggling to be able to identify what that would be right now. So I think anything in relation to businesses that would be trading, for example, would have to wait until we were all out of, or at least maybe if we were moving in a positive direction, the lockdown restrictions were lifting, for example. Just seen a question from Adam in relation, will the impact be minimal in Barder type events if they're relatively rare events? That's an interesting one, because of course, one part of the analysis contained within Barder is the fundamental assumption, is invalidating the basis of a fundamental assumption. So on one analysis, you could say it's proportionate. How much did it invalidate the basis? How, and is that balanced out by the significance of the event. On the other hand, you could also analyze it as a binary. This order simply cannot work because this Barder event happened. So we need to reassess everything. It depends on the event, firstly, and it depends on the impact. If the impact would be on a minor component of the order, that might be resolvable with less interference. If the entire order, as was the case in Barder itself, just doesn't make sense anymore, then there needs to be a dramatic reconsideration of it. So it will be proportional. I can't say that it will always be minimal, it will always be great. Manisha's put in another question. If the client wishes to settle now based on pre-COVID valuations, would it be negligent to do so if we think values may change post-COVID? I think the broad answer has to be yes. If your advice is, well, we have a valuation pre-COVID or even during, depending on how long it is, and it's a significant asset that can swing the balance either way. I think negligent might be too strong, but I think you do have to advise them that it may not be sensible to consider the situation, particularly, let's say, if it was a high value asset pre-COVID and could sustain that or retain that or return to it when we come out on the other side. So I think we do have to be advising clients, and that's one of the examples, Venetia, to your previous question I was talking about. If it is a situation where you didn't have the full information in the first place, then you can't encourage your client to engage in negotiations. At the same time, you're struck up against, we don't even know what the situation is on the other side of this. And as we all find ourselves often is with clients who are keen to just get away from proceedings, which they might be under pressure to in these circumstances because they don't know the future. But I think that must be right. You can't advise a client to settle with the uncertainty, which puts me back to the actions we can take, which is accept that there will be delays going forward.
Okay, well, I can't see any more questions coming through, but obviously if any questions do spring to mind as we move forward on Barder. Oh, sorry, one more just jumping through from Caroline Falkus. What time is it? Yeah, let's
make this the last one.
Then yeah, we'll make this the last one, and then we'll move on. So what about a bankruptcy as a result of COVID-19? And then, oh right, and then I think Adam is just responding to what's being said exactly as it's applied. Yeah, so what about a bankruptcy? Well,
that's a tricky, I mean, again, I'm just trying to think in a circumstance right now, if the COVID-19 event has produced a bankruptcy after an order, I hadn't thought about, because of course there are Insolvency Act actions available in relation to bankruptcy anyway, but would it count as a Barder event, or would you simply go, I feel the normal insolvency approach would apply. I don't know if you would need to come to it as a Barder event.
Yeah, I'm not sure whether, I mean, maybe we can have a look at that and come back to you, but I don't know whether in the circumstances that would necessarily be a Barder event, or whether it would, simply be something that does from time to time happen in certain cases where after an order is made, there is a bankruptcy and then that's dealt with in the usual way in insolvency proceedings. I suppose it might depend on what stage of the proceedings you were at and the extent to which it affected other assets or resources. I don't know
my feeling is that doesn't constitute as a Barder event. I'm sure somebody may disagree with that, but there are actions via the Insolvency Act that I think that would be the normal procedure. I'm just trying to think if there was no COVID-19, you went bankrupt anyway, that would be the procedure in any event.
Adam's giving us a bit of encouragement. He thinks we're right.
Yeah. Thank you, Adam. Thank you, Adam. Right. I think thank you for your questions. We'll obviously be still feeling them through. I think we'll move on to the indirect contact point. I'll hand over to Rachel.
Thanks so much. Well, as you'll all be aware, there's been a huge amount of guidance that has come through, and basically since right at the very start of this crisis and pandemic. The first piece of guidance that came through was from CAFCAS on the 23rd of March. And immediately in that first piece of guidance, we had reference to where contact is not possible due to one parent having to self-isolate, that contact by way of Skype or FaceTime was immediately recommended. That piece of guidance was then followed up the following day on the 24th of March by the President's guidance, which confirmed the government's guidance at that time, which allowed for direct contact to continue happening where appropriate, but did clarify that it did not mean that contact must happen, but only that it could happen if that was appropriate. And really the overarching message of the President's guidance has been that if the letter of any child arrangements order can't be followed, then the spirit of it should be. And again, that to maintain contact under the stay-at-home rule, that they should be done remotely by way of FaceTime, WhatsApp, Skype, Zoom, or any other video connection. And if those aren't possible, then by telephone. So that is where we're at, where really the focus of keeping arrangements in place, particularly where there is any distance between parents, particularly where people would have to take transport or other things, and it's just not considered that direct contact is going to be possible, that the move is towards indirect contact. And our purpose of looking at that is to look at really some of the pitfalls and some of the things we need to be thinking at when we're thinking about indirect contact. In terms of local authorities, the view seems to be the same there. So if you're dealing with public law proceedings, clearly under Section 34, a local authority has a duty to promote contact between a child in their care and relevant parties under Section 34 and Schedule 2 of the Children Act. Unless, as it says under paragraph 15(1) of Schedule 2, it's not reasonably practicable or consistent with welfare. Some new guidance has been published in the last couple of days for children's social care services, and that covers contact for children in care. And what that guidance says is that contact arrangements in these circumstances will be assessed on a case-by-case basis, which seems to make sense, taking into account the guidance on social distancing. And again, where it's not possible to have face-to-face contact, what the guidance says is that that contact will need to take place virtually. So both in terms of public law and private law proceedings, what we have is a real emphasis on spirits of child arrangements orders being adhered to, but virtually. So the question really for us as lawyers is indirect remote contact qualitatively distinct from direct contact? And really, I think traditionally when we're looking at contact, indirect contact has sort of been treated a little bit as the sort of poorer brother of direct contact, that it doesn't really have the same impact. But in this time where it's become king, we now need to look at how that is promoted. In terms of the law, what we know is that Section 1(2)(a) of the Children Act provides that involvement of a parent in a child's life can mean direct or indirect contact, so it's covered there. Similarly, there's no express wording within Section 34 that states the local authority must promote face-to-face meetings, but rather that the local authority must endeavour to promote contact and allow reasonable contact. So again, that's inclusive of indirect contact as well. And from a legal standpoint, there's no implication that indirect face-to-face contact, is somehow deficient in quality, and that it can't be a really good way of children keeping in touch with parents. So in terms of indirect contact, one of the problems is where we need supervision. And obviously with contact centres closed, this is going to be a real problem. And really we're not covering in this webinar situations where there is domestic violence or where it would clearly be utterly inappropriate for someone to try and support indirect contact, which would put either themselves or their children at risk in any way. That is something that's a totally separate issue, which needs to be dealt with in a very sensitive way. And in this time, it may not be appropriate for that contact to happen at all, where supervisors and contact centres are not available to support that contact. This is more for situations where perhaps there are issues around knowing where someone lives, but that it's not completely impossible for contact to be supported by the resident parent. In terms of supervision, it may be that it's difficult for one parent to supervise that contact. And so there may need to be some consultations with other adults living in the home as to whether or not someone else might be available to supervise the indirect contact. And it does need to be done quite carefully. For example, we're using today Zoom, which has the chat function, which can be used while we're talking away on here. It's something that parents need to be aware of, that if there are any concerns about manipulation or inappropriate use of indirect contact, that functions such as Zoom, there can be private conversations going on while a more public conversation is going on at the same time. And for that level of supervision to be there if that type of communication is being used. On the other hand, we have situations of helicopter parents who won't allow any privacy where supervision is not required, where usually there would be no supervised contact, but they want the contact then to happen within earshot of them. Now, I'm going to come on to talk to you about the various rules around the use of technology, which may make it quite difficult in terms of children under 13 in particular, for them to be given access to technology and then just left on their own to use that. But I think it will be for each parent to consider on a sort of case-by-case basis whether or not it's appropriate for a child to be left using technology on their own. So to go on now to look at the particular points about the use of technology, which I think we need to be aware of. In terms of certain technologies, so for example, I've read that Facebook has seen a group call increase of 1,000% in the last month. And I think all sort of forms of technology have seen similar increases. What we need to think carefully about is the type of indirect contact that's being used. In the UK, only children aged 13 or over are able to give their own consent to online processing of their data, which means that most social media platforms, Facebook, Skype, Snapchat, Twitter, Instagram, all have the minimum age requirement of 13. So children should be supervised when they're using these services by a parent whose account should be being used for the purpose of that contact. Now, note that for teenagers, since April 2018, WhatsApp has the youngest age of 16 use of their services. So children under 16 should not have their own WhatsApp account under the WhatsApp rules. A really common problem is where parents don't want to use or surrender their telephone numbers. So what other tools can be used then? There are various conference call services available. For example, YPay, which is spelt with a question mark at the end, that can be used within a bundled package of minutes from both landlines and mobile phones, although they'll have to look with their provider as to how that would work, particularly with their network. And the conference calling feature means that they won't get one another's phone numbers. Similarly, Facebook Messenger won't share your phone number, but will share your username and profile. So it may be envisaged that there might be situations where a parent might set up a very limited profile on Facebook with some very limited information on there for the purpose of indirect contact in that way. Where there are concerns about location information being disclosed, WhatsApp probably isn't the right form for parents to be using, as users can share real-time location information from WhatsApp very easily, and children could very easily share that without realizing. Obviously, as with all forms, we need to be very careful about allowing identifiers in the home to be visible. And one of the great features of Zoom, obviously, is that you can put a background in the way that Adrian and I both got the sort of Coram backgrounds, that you can put a background which completely blocks out where you are. And children will often really enjoy using the kind of different backgrounds that they have available. It can be another sort of fun feature, but clearly parents need to be careful that if children are skipping between various backgrounds, that in between those backgrounds then aspects of the home may be available, and to ensure that anything that would identify where they are if they don't want their location to be known is out of the way. Skype also allows for the background to be blurred, which may also be helpful. Thinking about privacy, there are obviously situations, as we're all aware, where parents want to get other people involved, whether those are grandparents or step parents or anyone else who parents want to have involved in the indirect contact, but where there hasn't been an application, and for whatever reason our client doesn't want those grandparents or anyone else to be having contact with the child. Now, where you're in a situation where everyone's in the same home, that's going to be increasingly difficult, and there will need to be some very clear boundaries around who is allowed to join that call. Now, with Zoom, obviously the address for joining any meeting can be shared with anyone. And so it may be difficult where one parent would share the details of the meeting with grandparents who could then join. So that's something that parents will need to be very careful about and think about when deciding what form of indirect contact they might want to use for these types of sessions, indirect contact sessions. The last thing that I think just needs to be drawn to our clients' attention as well, and it's really less of a legal point and more of a sort of general point, is that use of video technology in the kind of circumstances that we're talking about is clearly should be safe if used in the right way and the appropriate tools are used. However, getting children used during however long this period takes us through to using video technology may place them at risk of thinking that all video technology is safe. And that may just be something that parents need to be live to, and that perhaps we need to be live to, that where children are being encouraged to use this type of technology for their intimate and familial relationships, they need to be also explained to that not all types of video technology is going to be safe. So in terms of just thinking about implementing and managing arrangements now, I think if we're agreeing orders now, indirect contact provisions need to be really carefully identified, as carefully as we would with direct contact proposals. So there's no longer an era where indirect contact can be sort of just shoved in there at the end. It's got to be really clear what time it's happening, where it's happening, who's going to be supervising it, what type of medium is going to be used, how long it's going to go on for. Zoom, for example, if your free service was cut out after 40 minutes, I understand, although they were saying that they might extend that during this time, but the initial period was 40 minutes for the free service. Need to also be thinking about supervision of digital handovers. So how, if one person doesn't want to hold, how the handover to the person having contact is going to happen, and to think through very carefully, obviously, if there are any domestic abuse issues, how those are managed, and whether or not anyone else can supervise that by way of an online. So whether or not someone remotely could, for example, set up a Zoom meeting and could manage it in this way, but who's not in the household. That might be one way that contact could also be managed. So those are really our key sort of points. In terms of any issues of enforcement in this time, clearly Practice Section 11J covers that. What the court sent out some guidance on the 3rd of April is that all applications to the court should be made online. If anything is urgent, if it needs to be heard within 3 days, then an application should not be made using the online process, but practitioners should contact the courts directly. So they should contact their local court directly to have it listed. On paper applications should only be used where matters aren't urgent, or if for whatever reason someone can't use the online processing tool on gov.uk. Right, I think that's my quick run through indirect contact. I don't know if we've got any questions.
And you've already got one from Adam again. Is there a sanction if the resident parent does not allow the non-resident parent actual physical contact due to this crisis? Is this an exception?
Well, I think it's really, it really is going to depend on the circumstances. It's interesting that in terms of the guidance that came out initially, that the CAFCAS guidance, I think if I remember, had made a point about contact being made up at the end of this period, and that thought should be given to that, whereas the President's guidance was completely silent on that. And I think there may be some issues around, you know, contact over Easter holidays or contact over half terms being missed, and whether or not there will be any requirement to make that time up. In terms of contact not being allowed and any sanctions, obviously if it's reasonable, if a parent is for reasonable reasons, whether it's because of distance or whether because someone in the household has contracted COVID-19 and therefore has to self-isolate, or there are vulnerabilities in the child has very severe asthma or any other problems that might cause any issues, or anyone in the home is particularly vulnerable, then clearly there may be a reasonable excuse for not allowing contact to happen. But if it's something that can happen safely in a local area, you know, where traveling can be done, I don't know, either in a private vehicle or some other way that's safe, then that would seem to fall outside of when it would be reasonable to say that contact shouldn't go ahead. So I think our problem here is that we have to be looking at every case on a case-by-case basis, looking at it geographically and looking at all the issues that are involved in the family at this time. And so there isn't really a blanket answer to that. It's a really subjective case-by-case basis, looking at what the person either on the other side or what our client is saying the reasons are that direct contact shouldn't be going ahead. I don't know if you have any other thoughts, Adrian.
No, that's what I was just thinking. Just on that, I believe it was a few weeks ago, just as Rachel's point about the President's guidance, the President was quite, well, I say quite clear. The observations seem to be that, it was paragraph 6 of the President's guidance from a few weeks ago that might have been overridden by everything. But there would obviously, the implication is that the courts were enforcement proceedings brought. They would look at the circumstances of the denial or limitation of direct contact. I prefer to take the view in this current scenario that actually, and this is where we're bent towards, is that indirect contact actually becomes more important in the circumstances. There is this history that we all know, that you will be arguing about direct contact until the cows come home, and that strikes everybody, every parent, every client, as the premium type of contact. But we are all here able to engage with one another via the digital services. We need to be putting, going forward, whatever happens in the future of this, we need to be putting more emphasis on indirect contact and how valuable that can be in absence of direct contact. And I'm not just talking about in a dramatic crisis such as now, but holidays. How many times have we all just put in a provision for, well, parent on taking the children on holiday will put in a call to other parent whilst they're away with no specifics, no specific time frames, no specifics of software, how the arrangements are going to work. And I think the biggest thing to take away from all of this when we're looking at contact going forward is that we need to get we need to adapt more to the possibility of improving indirect contact as a medium on the whole. And to take a step further, in these scenarios where possibly practice direction 12J may apply, where there need to be restrictions or management of contact, indirect contact does need to be explored differently, I would say, now. It's something to think about, but I think we are all guilty in some way, shape or form of sticking the indirect contact on the end of the list while we negotiate the direct contact. And I would say that given the circumstance, we don't have the luxury of that anymore, if I put it no stronger than that.
Yeah, I mean, I think, you know, Section 11J, in terms of enforcement of orders where the contact has been stopped. I mean, what Section 11J2 says is that if the court is satisfied that the person hasn't complied with the order without reasonable excuse. Now, it would seem to me that in the current circumstances, there is going to be a strong possibility that there may be a reasonable excuse in light of the pandemic and in light of the restrictions and the guidelines that are upon us. I mean, that is going to have to be looked at on a case-by-case basis. But that is something that each parent wanting to enforce a direct contact application will have to be looking at, is whether or not it is reasonable for them to be requiring direct contact to go ahead, or whether or not, as Adrian said, indirect contact could, for the time being, replace that. I think also we need to also be thinking very practically for our clients about things like data packages and bundles, whether or not people have internet at their home, whether or not they have smartphones, whether or not they have data packages that in lieu of internet at home would allow for calls to go ahead by way of any of these online services. And that is something that, you know, would also need to be broached with clients, is how practically are you going to be able to manage this? If you need more data, is that something that we need to broach with the side that, you know, we need some support, or we need to ask the local authority for there to be something put in place so that that data is available to facilitate that indirect contact as and when it has been agreed that it will happen. So practical things like that also need to be thought through, I think, as well.
I've got another question. I've got a question from Kirsty, and actually, Kirsty, this is a very, very good point. I think video contact is valuable. Is it correct to call it indirect contact, given that there is face-to-face, albeit remote? Some judges are more open to viewing it as a form of direct contact. I think, Kirsty, you are absolutely right. I think the distinction between direct and indirect contact, they're terms of art we're all very used to using. There should really be a case to consider calling it digital face-to-face, some other mechanism through it. I mean, we're all used to knowing the distinction between direct and indirect contact, but I think that's a very, very valuable point, that after all of this, what are we even going to call it anymore? Because it's not FaceTime, Zoom with video, with webcams, it's not indirect contact in the same way, say, letterbox or telephone could be. And even then there's an argument to say that telephone with real-time responses may not necessarily count. I think letterbox is probably more realistically described as indirect contact, but I think that's a very valuable point, and something we should all be moving towards, is let's just start renaming things.
I mean, I think the reality is that, you know, albeit video calls and video technology is great, it's, in most cases, it's not going to replace having actual direct physical contact between a parent and a child, which is, you know, valuable for all kinds of reasons. But I think you're right that it's what it does allow is for children to see their parents, to see, and depending on how it's used, you know, if there are games that are played or things like that, then obviously there is that form of contact going on, albeit, you know, quite often you're just seeing someone's face rather than their whole body or how they look. So I think it is quite a grey area in terms of whether or not it's direct or indirect, and I don't know. Perhaps we're wrong in classing it as indirect. I don't know. Right, more questions.
Another question. Let's go.
Samuel.
From Samuel. So perhaps a note of caution about something I have regarding Zoom and the discussion of privacy and safeguarding. My understanding is that if a host chooses to record a Zoom meeting locally, then chats sent publicly, as well as any private chat exchanges that the host who chose to record the meeting participated in during the sessions are saved. That I didn't. So Samuel, you're saying that, for example, private conversations that are happening in the Zoom chat that aren't chatted out to everyone would also be saved as part of the recording, which could be actually quite concerning if that's the case.
Actually, I can chime in on that one. That is absolutely true, because the host of any Zoom meeting has full control over everything, the recording, where it's saved, whether it's up to a local drive or to the cloud. So that could pose a pretty big issue, actually. Good point.
But I think the same in the same way that covert recordings are dealt with usually in the proceedings that we dealt with, if someone was covertly recording any kind of contact using either Zoom or anything else, that would be treated in the same way that covert recordings are treated in the courts generally. So I think it would fall under the same categorization. I mean, I think what I've been saying is that where there are concerns that someone else might try and record a contact, that the person who is concerned about that should be the one to set up the meeting, because then you get a notification if the other person is trying to record it. I mean, the problem with that is that you only get a notification if someone's using Zoom itself to record. Obviously, if someone's using their phone separately to record it, then you're not going to be able to know that. But it's one level of safeguard that at least through Zoom it can't be recorded without your knowledge. But I think, yes, that will, I'm sure, happen, and I'm sure we'll have clients coming back with, I've got this recording of that, or got this recording of that, and we'll just have to give them the same advice that we've been giving about the way the court will view covert recordings generally, is my view as to how that will be treated.
Any other questions related to either of the discussions, everyone? Oop. Adam's just said it is a fine balance and a fairly low risk. In the unlikely event that it was used in proceedings, then objections can be made to the judge taking account of many factors. That's correct. Yeah,
of course. And it's generally not considered great, is it? I don't know if anyone has any other, like, not just on the Children Act, so anyone else has any questions on Barder, or any other questions at all, if you want to throw them our way as we come to the end. We've got 5 minutes left. If not, then you can have an early lunch.
Assuming you haven't been already having it, of course. Everyone is on well, I think, shall we wrap it up?
Okay, great. All right, well, thank you so much, everyone, for participating in Zoom. I hope that you have enjoyed it. As we've said, please do donate to the Just Giving page if you would like to. Please do join us on Thursday for our second COVID-19 Coram webinar with Caitlin Ferris and Victoria Roberts, who will be discussing public law and COVID-19. Please do give either Adrian and I a shout after this webinar if you have any follow-on questions or anything you'd like to discuss. Thank you very much for joining us.
Do take care. See you soon.
Thanks.